Giant Google's official slogan is "Don't be evil." Gmail, its internet email service, has 425 million users worldwide. It is the biggest in the world. But Gmail is also the subject of one of two privacy lawsuits that Google is fighting in federal court. In the first, Google is accused of violating federal and state wiretap laws by automatically scanning emails looking for personal information that is then used to generate targeted ads and services. The second suit stems from large amounts of unencrypted personal data that Google secretly took from home computer networks as its Google Street View cars mapped and photographed streets in 30 countries around the world. Google has sought unsuccessfully to have the suits dismissed. For more, I'm joined from Los Angeles by John Simpson, Privacy Project Director for Consumer Watchdog, a nonprofit consumer advocacy group. And with me from San Francisco is Julia Love, a correspondent with American Lawyer Media. Great to have you both with us. John, I want to start with you. We hear all the "don't be evil" stuff. What is really evil about this? What's the big deal?
Well, look, I mean, that's their motto, but in fact, I think over the last few years, Google has demonstrated itself to be something of a serial privacy violator. And I think in both of these cases, there were significant decisions, one by an appellate division, that wiretap laws were being possibly violated, and that suit could go forward. And in the Gmail suit, the judge said the same thing.
But they're basically, what they're doing, you can probably explain this better than I am, is that they're scanning in an automated way. They're going through these emails that people send, and they're just picking up keywords to, for example, my son plays tennis, and all of a sudden, I remember a couple of years ago, I started getting all sorts of information about tennis, all sorts of tennis-related ads.
Well, they're doing much more than that. I mean, it's one thing to scan and to see and check whether there are computer viruses there and malware and that sort of. Google goes much farther into the data mining, and they not only use it to target ads, but they build profiles on individual users. And they're doing this without most people's understanding and or permission and consent.
Julia, don't most email services make money mining messages in that way?
Well, there's something of a split among email providers right now. Yahoo and Google do scan emails that pass through their systems, but some, like Microsoft with its Outlook system, do not. And Microsoft has actually held that up recently with its Strudel advertisement campaign.
But I guess in the end, how does that hurt the users? Julia?
Well, the plaintiffs contend that the users are harmed because their privacy is being violated, and the plaintiffs claim that even Gmail users have not consented to have their communications intercepted in this way because the privacy policies are not explicit about how the communications will be intercepted.
All right, let's address that. Google tells people who use its products their emails will be mined for content according to Google's privacy policy. Here's the quote: "We collect information to provide better services to all of our users, from figuring out basic stuff like which language you speak to more complex things like which ads you'll find most useful or the people who matter most to you online." But that didn't stop U.S. District Judge Lucy Koh from writing in her ruling last month. Here's another quote: "The court finds that it cannot conclude that any party, Gmail users or non-Gmail users, has consented to Google's reading of email for the purposes of creating user profiles or providing targeted advertising." My question, John, is that would it have avoided any issue by just being really straightforward about its privacy policies and just, not hiding this in fine print?
I think part of the problem is that you're exactly right. I mean, they're very, very vague about what it is they're actually doing, and if they were upfront about it, that might have solved the problem for people who are Gmail users and who have Gmail addresses. It doesn't solve the problem for somebody who sends from another email system. I mean, if I'm using Outlook or Yahoo, when have I ever agreed that Google could intercept my personal messages.
Right, because if you send me, a Gmail user, an email, it's not just the emails that I'm sending as a Gmail user, it's the emails I'm receiving that are also being scanned. Now we have a viewer...
It's more than scanned. I mean,
yeah.
Scanned is what you do to check and see whether there's a virus. And, you know, and it's also perfectly sensible to figure out, you know, from the metadata where you're supposed to deliver the email and that sort of thing. But to actually go into the content is a tremendous intrusion of privacy. If some people were willing to give that up in exchange for free email, perhaps if there was an explicit explanation of what was going on, that might be acceptable. But Google has never come clean.
We have a viewer question. Let's go to our social media producer, Hermela Aragawi, for that.
Thanks, Antonio. John, viewer Andy asks, how can Gmail wiretap a service that they offer and that we voluntarily sign up for?
Track 15, take 15.
Wiretapping under the law is involved in intercepting the messages, and they were trying to suggest in their motion for dismissal that all this was part of a normal, ordinary business practice, and the judge found that it wasn't, that the kind of interception that they're doing is not a part of essentially passing on the email message. And again, the other aspect of this was consent. Now, what the judge also said was that she did not think that the average user had given consent because Google hadn't explained what it was doing. So that's the heart of the case, and she's essentially said, okay, in that circumstance, they can go forward with a class action suit, and it's likely to be scheduled, I think, sometime next fall.
And Julia, I mean, John brings up this ordinary practices, business practices issue, which goes back to a law that was passed in 1986. Before all this became, obviously, a lot has changed in the past 27 years. So is part of the problem the law just simply hasn't kept up with reality?
Yes, I've spoken with lawyers who think that the Electronic Communications Privacy Act has always been problematic, but as it came about in the age before email was prevalent, judges are being called upon to decide how email comes into play. And what Judge Coe has determined is that Congress did not intend for email providers like Google to have unlimited leeway in the course of its ordinary business practices. And so while Google is arguing that scanning emails to help sell ads falls under its ordinary business practices, Judge Coe finds that ordinary business for an email provider is transmitting email.
And Google made the same argument in the lawsuit about its Street View cars getting information, unencrypted information from the houses it was going by.
There was a little different argument there. They were claiming they were exempt because it was radio transmissions and that the broadcasts were readily available to the ordinary people, and the judges found that neither of those things were true.
You know, what happens if Google ends up losing these lawsuits? Julia?
Well, some are concerned that email providers may have to change the services that they offer users because automated processing is used not only to help sell ads, but also to allow users to search their inboxes or filter messages. One thing that's for certain, though, is that Google could be on the hook for millions of dollars in statutory damages and lots in legal fees,
If this last one becomes certified as a class action lawsuit, the fines could be enormous if you've got 425
million. It could be in the
users.
Billions.
Yeah. Plus people who correspond with them.
Right, exactly. The people who correspond with them on top of that. So you're talking about almost any internet user in the world, probably. John, a final question. How do you compare what Google is doing in the email scanning and data mining to what the National Security Agency did with all the meta data that it got, you know, about phone calls?
Well,
is this more intrusive in a way?
Well, look, one of the reasons the NSA was able to gather the data that it did is because Google's got it. And I mean,
well, and that's the thing. And Google has much more. I mean, Google, in effect,
Google has much more, and
the whole text of the emails, right? I mean,
yes.
So how much worse is this if they already have the emails themselves, just going through them and getting this information and creating a user profile? Why is that any worse
Well,
than
one
having our
of the reasons is that there is the possibility of access to that without appropriate warrants, which is what was going on with the NSA. So that's very troublesome.
I know, a lot of privacy issues these days to think about and to talk about. And John.